Hi, my name is Martina Swiga. I'm an advocate of the High Court of Kenya and I'm a practicing advocate, and I just want to give legal ease instead of legalese, like bringing legal concepts into very simplified terms. I wanted to talk about what bail or bond is and where does that apply. So, when there are criminal investigations that are against you, like you're being investigated for a crime, or in the event that you're facing a trial, that is where bail or bond is applicable. So, bail essentially allows you to be free or to exercise your right of liberty even while investigations are pending against you and while the trial is going on. So, pretrial detention essentially means the confinement of an accused person or a suspect pending the completion of the investigations or pending the trial. Okay, so what exactly is bail? Bail is number one, a right. However, this is a right that can be limited. The basic explanation of what bail is that bail is where an accused person or a suspect and their sureties, I'll get to that later, undertake to attend investigations or attend trial, and so they are then given the right to liberty even as this process takes place. So it is when you promise or undertake that you will attend court, you will attend summons, when you're called by the investigator, you can go, you will be found. If they need to find you, they can find you, basically, so that even if you're going through the criminal process, based on the fact that you're presumed innocent, you can still exercise your right to liberty. That is as opposed to being in a police cell or being in custody of, you're a guest of the state. So there are types of bonds or types of bail. You can be given a police bail, which is essentially being given at the police station. They can either they can give you like a cash bail, or they can even give you a free bond that, okay, you just go and make sure you always come when you need you for investigations. For court bond, it's essentially granted in court. And there are two types I want to explain. There's what we call anticipatory bail, which is primarily granted in the High Court, where you're anticipating to be arrested or you're anticipating to be charged. So you rush to the High Court to get that anticipatory bail, so that even when the police come and start investigating you, they don't have to arrest you and put you in custody. You will only appear at the time when you have to go to court. There's also the bail and bond that is granted in court. For instance, you were given a police bail or a police bond. When they present you before a court of law, and after the charges have been read to you, then you will have the opportunity to ask for bail. Can I exercise my right to liberty even while these investigations are going on or while the trial is going on? Now, the prosecutor, or rather the state, may refuse or may ask the court to limit your right to bail. And they can do that only if there are compelling reasons. So if you have a representative, or rather an advocate, that is the best part, where the advocate comes in and argues for you to be given reasonable bail or bond terms. So I had mentioned a surety, and I want to define what that is. Allow me to read. A surety is a person other than the accused person who undertakes to ensure that the accused person will be present at the time required, either for trial, for summons, for investigation. So it's someone who stands on your behalf, and they come to court. They'll either come to court and be under oath and undertake or promise to be a surety. And if you are a surety, you need to understand the consequences of being a surety. That means if you deposit like a security, like maybe you've put some land to stand in as a security, or a title deed, or a logbook, or of a particular motor vehicle, you need to understand what exactly you are doing. Because should the accused person not avail themselves in court or not give sufficient reasons, because maybe sometimes you're sick. I mean, we live in Kenya. Tomorrow there can be mandamano, then you're not able to go to court, or any such reason, the surety needs to understand that any security that you have put in court can be forfeited by the state because an accused person has absconded. So don't be quick to jump to be someone's surety without knowing the legal implication of what that means. So the security is the money that has been pledged so that an accused can be released to exercise their right of liberty, even as a trial goes on. Trials in Kenya can take even up to 7 years. you can be in court for 7 years. So those 7 years, instead of being in custody, you can exercise your right even as you're trying to defend yourself and vindicate yourself from whatever it is you're being investigated. So bail is actually provided for under Article 49(1) of the Constitution, which gives you the right to be released on reasonable bail and bond terms unless there are compelling reasons. So there's a reason that the government can say we cannot release this person on bail or bond, and I'm going to get into that. So all offenses are essentially bailable, but you need a criminal lawyer so that they can thrash out or they can reduce these compelling reasons that will be brought against you, because the arguments for compelling reasons why you should not be released should always be countered. Don't just go there and start deterring yourself, because sometimes you actually need a representative so that they can argue out these issues of bail on bond. It's not just about saying, I need to be released, I have a family to feed. No. So, what are these compelling reasons that the government or the court can deny you bail? So, I need you to understand that the primary reason for bail is so that an accused person can be able to attend court or summons or investigations. So, unless these compelling reasons exist, there is no reason why you should not be granted this bail. The first compelling reason is if you're a flight risk. If they find you with several passports, of course they know you're a flight risk. There is no way you're going to be given bail or bond. If you do not have a fixed place of abode, or they do not know where you come from, like you say, I live in this particular building next to this church, house number this, that means they can find you anytime, and then there's no reason why you should not be released on bail. There's also the reason about interferences of the witnesses. But this interference of witness, it must be an actual interference. It just cannot be anticipated. It must be real and tangible. And that is when now your lawyer will argue all those cases where the court found that it is important for the state to produce actual interference, or it cannot just be based on speculation. So if there's a likelihood that you'll interfere with witnesses or you'll interfere with the investigation, you're not going to be released on bail. They could also limit your right to bail in case you have a past record of like offenses. They can also put you in custody if, for example, you did a crime that has been really condemned by the community, and the court is of the view that you should be inside because it's safer for you being in custody as opposed to you being in the community. Then they're going to limit your right to bail, because at the end of the day, the state has a responsibility to protect the right to life. Also, the need to protect the victim of the crime, that can also be a compelling reason. And finally, the nature of the likely punishment that you are going to get should you be found guilty, should you be convicted of the crime. However, that one you can always argue it out, because there's the presumption of innocence, which is actually protected under the Constitution. Yeah, so in a nutshell, that is what bail and bond is about, and there are guidelines that are normally used by judicial officers in deciding whether you're being granted bail or bond. This information is important because at any one time you can be investigated for anything, and the DCI, or rather the police, have the right to investigate you. It's their statutory right. But even as they exercise their statutory rights, you should also know how to protect yourself and how to further your rights. And that was my take about bail and bond and what it's about and where it's applicable.